Good afternoon, Professor Ida Caracciolo. It's an honor for us to have you here. Professor Ida Caracciolo is a judge of the International Tribunal for the Law of the Sea, a professor of international law at University of Campania, Luigi Vanvitelli, member of the Italian Society of International Law since 1996, of the European Society of International Law since 2005, of the Italian Society for International Organizations since 2000, and the Human Rights Committee of the Italian Society for International Organizations since 2006. Professor, you have 1 hour to make your presentation, and after that, I will address you some questions from the audience, both from Zoom and YouTube. Professor, the floor is yours.
Thank you, Professor Sachett. And before starting my lecture, I'd like to thank you all for your invitation to speak about the law of the sea, which is a topic that I not only study since a long time, but that I really love, maybe because I'm Italian, so I live in a country surrounded by the sea, in 3 sides out of 4. So Italy is a sort of bridge in the middle of the Mediterranean Sea. So probably this is a sort of influence of the surroundings to me. Well, my lecture will be on freedom of navigation, some theoretical and some practical issues on this topic. Everybody knows that freedom of navigation is of particular importance in international relations for economic and strategic reasons, which are strictly intertwined. So international law has been involved in the regulation of navigation and also fishing since earliest times. Just to introduce some historical perspectives, the problem of the regime of navigation was posed for the first time during the 15th and 16th century when Spain and Portugal claimed the ownership over the Atlantic Ocean in order to have a direct connection with their colonies on the other side of the Atlantic. These pretensions gave rise, of course, to counterclaims by other countries, and it is really singular, and I think that we will have to maintain in our mind these starting points, that the concept of freedom of navigation was for the first time defined and described in an advice given by the Dutch jurist, everybody knows, Grotius, to the Dutch East India Company, where Grotius argued that the Dutch India Company was allowed to trade in East India, notwithstanding the Portugal's monopoly on trade and claims on sovereignties. And so the book of Grotius, Mare Liberum, was a part of an advice given for very practical reasons by Grotius to a company which was formed by tradesmen engaged in trade with East and Western Indias. At least at the end, freedom of navigation prevailed for various reasons, because trade was a very important issue, and it is still a very important issue, because states wanted the freedom of navigation for security and military influence, and last but not least, because states was unable to sustain their claims of controlling large, huge portions of oceans. So the idea that shipping must be free was maintained along the centuries and was codified by the UN Convention on the Law of the Sea in 1982. But the maintenance of these principle of freedom of navigation wasn't an easy task, in the sense that, and I'd like to repeat the what O'Connell, which is a very famous was a very famous scholar on the law of the sea, wrote on that issue. The law of the sea has been dominated by a central and persistent theme: the competition between the exercise of governmental authority over the sea and the idea of the freedom of the seas. So to put together these evidently opposite positions was a very hard task, and has resulted in many compromissory solutions. I will say that UNCLOS is full of compromises, especially in the field of navigational rights and freedoms. So we can say that the freedom of navigation, it is, of course, a well-recognized principle. No state criticizes or sustains that no principle, no freedom of navigation exists. But there are numerous attempts, numerous interpretations which try to reduce, in certain peculiar cases, the meaning of freedom of navigation. Also, because, as you know, compromises are very often obscure. To maintain opposite positions, it is necessary to write very complex rule, which pose usually interpretative problems, or which can be interpreted according following different positions. So my intention, and I hope to succeed in this lecture, is to show you the most, let's say, complicated points within these overall regimes of freedom of navigation within the UNCLOS. We do not have enough time to analyze in depth all aspects, but I will try to highlight the most problematic one, where there is a struggle. There are struggles again between opposite positions and interpretations. Let's say that first point, speaking about freedom of navigation doesn't mean focusing only on the high seas, since we find freedom of navigation in all regimes contained, established, codified by UNCLOS. In the territorial sea regime, in the navigation through international straits, in the regime of the exclusive economic zones, and of course, evidently, in the regime for high seas. In all these regimes, we find various declinations of the freedom of the principle of freedom of navigation. Sometimes the expression freedom of navigation is directly utilized. In other cases, there are other expressions which are utilized, like innocent passage, but which in substance are cases of freedom of navigation. In addition to a sort of territorial freedom of navigation, so declined according with the different maritime areas, we have also a sort of freedom of navigation admitted by bilateral or multilateral agreements, through which states can accord to other to their counterparts some some navigational rights and freedoms. Let's say even so, starting with our navigation to understand the thorny aspects of the freedom of navigation, we must say that even in internal waters, we have some claims concerning the existence of a certain freedom of navigation. As you know, internal waters are not ruled, are not disciplinated by UNCLOS, since internal water are parts of the territory of a state. So we know and the and it is commonly sustained that in internal waters no freedom of navigation exists, since the coastal or port state is authorized by international law to decide which ships admit in its internal waters. But I must tell you that several cases before ITLOS have posed the problem if it is possible to sustain that there is a right to exceed the high seas from the internal water. So if foreign ships enjoy the right to reach the high seas from internal waters. ITLOS has always replied in a negative way to that claims. We can remember the MV Louisa case, but also the North Star, more recent North Star case, which was Panama against a case brought by Panama against Italy. The tribunal concluded that foreign ships have no right of navigation in the internal waters unless this right is conferred to foreign states by the convention, which was not the case strictly the case in the MV North Star case, or because of other international law rules. I must say that the fact that the absence of freedom of navigation in the internal waters and the absence of a freedom to enter ports by foreign ships has been largely utilized by states during this pandemic period. Because if we have a look to state practice in the last, let's say, 1 year and a half, we will see that most states closed their internal waters and their ports more or less fully to foreign ships in order to try to avoid the pandemic in their territories. The territorial sea. In the territorial sea, we know that the compromise between the extension of state sovereignty to the waters of their coasts and the freedom of navigation was reached by limitation of state sovereignty given by the principle of innocent passage. Innocent passage is really a very complicated principle. If we read the rules contained in the convention in UNCLOS, really we cannot sometimes clearly understand their meaning or their scope of application. We know and case law, and especially state practice and doctrine are rather uniform in affirming that foreign ship, the innocent passage is conditionated by some requisites, and in particular that foreign ships must navigate in a continuous and expeditious way, and that their journey, their passing through the territorial sea must not be prejudicial to the peace, good order, or security of coastal state. But if we think, what does it mean, continuous and expeditious? And they are rather clear terms, but we can decline them in different way. We can have something very rapid and something less rapid, and something less continuous and something more continuous. So to understand how to comply with the rules contained in UNCLOS is not easy, especially if we suppose that coastal state will have a strict interpretation of these adjectives, while the flag states will tend to give them a larger scope of application. Another point, another less unclear point, when the passage does become prejudicial to the coastal state. We know that we have a very milestone in this field, which is given by Article 19. But Article 19, as you know, it lists a series of activities which are considered to be non-innocent. But there is also, at the end of this paragraph 1 of Article 19, a sort of opening clause which admits other hypotheses out of the cases listed in Article 19.1. We have to take into consideration that Article 19 uses the expression activities and not manner. So it is not not the nature of the ship, but it is the activities that the ship must be involved in while navigating in the territorial sea. So let me just mention the big problem caused by military vessel. The military vessel in itself is not a vessel whose navigation can be prejudicial to the coastal state. It is the activities that vessel could carry on during its navigation. But frankly speaking, I have to tell you that states practice is rather uniform in limiting the navigation of military vessel within the warship, in particular within the their respective territorial sea. So giving to Article 19, paragraph 1 and paragraph 2 a different a slight different interpretation, so focusing on the type of the ship and not on the activities of the ship. So this leads to asking a sort of prior notification of the entrance by a warship in their territorial seas, or in certain cases also an authorization, a prior authorization. The other aspect, rather complicated, is the legislative jurisdiction of coastal states in their territorial sea. Because thinking about an extension of sovereignty, we could conclude, well, the coastal state discipline everything happens in the territorial sea, but this is not the case, in the sense that we have always the remnant of the ancient freedom of navigation. Coastal state discipline safety of navigation, navigational aids and facilities, the protection of cable and pipelines, the fisheries, the environment, its laws concerning customs, immigration, but it doesn't discipline everything within the territorial sea, because there is a limitation given by the innocent passage principle. So consequently, we cannot say that any violation of state rules amounts to a violation of the principle of innocent passage. Let's say automatically limited also regulatory competences of coastal state are limited. If we think about the possibility to suspend for the innocent passage, we know that suspension is a very curtailed competence of the coastal state. And not to speak about jurisdictional, criminal jurisdiction and civil jurisdiction, which, if we read Article 27 and Article 28 of UNCLOS, are at the same time a sort of shared functions between coastal state and flag state. Just let me remind you a case which involved Italy. It is a very famous case. It involved a cruiser having the Italian flag, which was which was in the Egyptian territorial waters. This case happened in 1986 and was hijacked by a group of terrorists from Palestine. Egypt didn't claim its criminal jurisdiction, so the jurisdiction was claimed by Italy as the flag state. But this position was contested by the United States, since the only victim of this hijacking was a U.S. national, which was killed, was an elder person on a wheelchair who was killed by the Palestinian in order to sustain their request of freedom for some prisoners from Palestine, which were in the prisons, Israel's prison. In jail in Israel. So you see how delicate can be the case of deciding whose state has the right to exercise its jurisdiction in criminal matters or civil matters, even if we have two rather articulated rules in UNCLOS. Other problems we find, and I will say even more complex, concerning the freedom of navigation in international straits. All the times I read the rules contained in UNCLOS, I arrives to the point that it is an extremely complicated regime. Well, the regimes are, because we will see we have more regimes, are extremely complicated, and they respond to different objectives. So if a lawyer, an international law scholar, must interpret a convention according to its objective and its scope, well, the existence of different objectives within the multiple regimes of navigation in international straits, we have, this is a problem, and we have to take it into consideration. You can imagine that when the territorial sea was expanded up to 12 nautical miles, the big part of international straits, which were included in international waters, which were included in the high seas, were changed the regime, and they have been included in territorial seas. So most waterways which were freely utilized for navigation, think of Gibraltar for the Mediterranean Sea, but think of Torres Straits in the Australia. Think of the straits in Indonesia. The Malacca Straits, to mention you another very important choke points, the Straits of Hormuz, just to give you another, through which all oil transport passes, because it is open to the countries of the Persian Gulf. Think all these waterways which were parts of the high seas, which have become parts of territorial seas. So during the negotiations of the convention, states were really very strong in sustaining their opposite positions. So the result was a compromise. The result have been compromises and compromises. In a very difficult effort of balancing opposing interests. So at the end, what we have a regime of transit passage. I won't deal with it because it is extremely long, but just to give you the idea of transit passage, which applies to straits used for international navigation between one part of the high seas and an exclusive economic zone, or another part between two parts of the high seas, or two exclusive economic zones, or a part of the high seas and an exclusive economic zones. Here we have the freedom of navigation. Indeed, coastal bordering states, the straits states, have very limited legislative and enforcement competences. Just think that they cannot hinder the continuous and expeditious transit of vessels through their straits. Even in they cannot board the passing vessels. They cannot, of course, inspect them and all the rest. They cannot suspend the transit passage. It can only, the coastal state, warn ship concerning a certain problem, hazard within the in the straits, it can, even in case of criminal jurisdiction, of use of force. If we read the words utilized by UNCLOS, just ask the vessel to pass as rapidly as possible. So I have the idea that in a certain way the coastal state is a sort of representative of the international community. It is called to guarantee the good functioning of the transit passage. Nothing more. This, of course, is a big problem for coastal states, which, of course, have security concerns and have also environmental concern. Just think about the coastal state of a strait through which several huge tankers pass through. And the need for the coastal state to protect its coast from the risk of pollution caused by a collision, just to give an example. Yes, it is true the coastal state can establish sea lanes, but maybe they are not sufficient to exclude the risk of pollution. But pollution can come also from the noises produced by ships or by the engines' fuel released in the sea. And well, the coastal state is without, I will say, munition if UNCLOS is interpreted literally. And so on the other side, we have the coastal state of straits, which try to go outside the scope of UNCLOS to force the meaning of the provisions contained in the convention. We have probably a way to solve the problem, which is more cooperation between flag states and coastal states. Cooperation which is envisaged by UNCLOS as a way to find a better balancing between opposite interests. But we do not have only the transit passage regime, which is, I will say, it is the most similar regime to that of the high seas. In reality, we have something very close to the freedom of navigation on high seas. But we have also the regime of innocent passage, which, for example, can be applied for straits formed by an island and a mainland. I'm very it was Italy which, during the negotiations, sustained the introduction in the UNCLOS, insertion in the UNCLOS of this regime, because of the Messina Strait, which is a strait which divides Sicily from the Italian peninsula. But we have also innocent passage for the so-called dead-end straits, so straits which are open to the territorial sea of another state, like the Straits of Tiran between the Arabian Peninsula and Sinai. And then we have also other three categories of straits submitted to different regimes of navigation. The straits wider than to 24 nautical miles, so which have freedom of navigation in between. straits which are regulated by specific conventions, specific treaties, which is the case of the so-called Turkish straits, and straits formed by internal waters of a state which are not open to free navigation. So if we think about innocent passage, we can think, okay, this is the innocent passage, so we know what it is, but well, it is not exactly the same innocent passage as in the territorial sea, because it cannot be suspended. While we know that innocent passage in the territorial sea can be suspended, even if for very detailed hypotheses. So you see, we have another declination of the freedom of navigation. We have innocent passage in a territorial sea, transit passage in a certain category of international straits, plus innocent passage in other categories of international straits. So another compromise reached to save as much as possible the freedom of navigation. But we have also an archipelagic transit passage, which is a sort which applies in archipelagic states such as the Philippines, Indonesia, and other similar state, which is a transit passage, but ships must navigate in well-established sea lanes. So if a ship goes outside the sea lane defined by the archipelagic state, it immediately enter another regime, the regime of innocent passage. So think how many compromises had to be reached in order to save the claims toward the controlling larger sea spaces of coastal states and the need to maintain the freedom of navigation, since the 80% of international trade goes by ships. And then we have another big compromise concerning the contiguous zone. I won't mention it, but the biggest, one of the biggest compromise concern the exclusive economic zone. The exclusive economic zone, as everybody knows, it's not anymore high seas. It's a functional area submitted to some functional powers, rights, and jurisdiction of the coastal state. But nevertheless, the freedom of navigation defined for high seas is recognized within the exclusive economic zone. So coastal state cannot discipline, regulate freedom of navigation, except for the protection of the environment, of course, and evidently, if the ship is engaged in fishing or scientific research. rights and the sovereign rights and jurisdictions of the coastal state are balanced by the freedom of navigation by third states. And both categories of states have to take in due regard the rights and the freedoms of the other category. I think that this due regard obligation is an important one, since it permits in an evolution, of course, also because of technological development of activities at sea, to maintain, to correct, to slightly adapt the balancing to new exigencies for coastal and flag states. But we have a compromise which is a good compromise, in my opinion, but which doesn't work for every in every situations. So I will just mention military activities in the exclusive economic zone. Here, UNCLOS is silent. This is an important difference from the territorial sea, where reference to military activities is contained. And of course, they are prohibited since they are contrary to the principle of innocent passage. We do not have any restriction about concerning warships. We don't have any mention about authorization to military activities. Nothing. So, of course, this silence has given rise to opposite, strongly opposite claims. Some maritime states maintain that for purposes of military activities and military exercises, EZ should be treated as high seas. So these activities are associated with high seas freedoms, freedom of navigation especially, so the coastal state cannot intervene with regard these activities. On the contrary, we have the position of coastal states, many coastal states, which claim the right to limit military activities in their EZ, affirming that these activities are prejudicial to their security interest. And so they tend, within this category, some of these states ask for prior notification. Others ask for authorization. And we must be very well aware that notification is something completely different from authorization, in the sense that prior notification is the way through which a coastal state may know if an activity could be prejudicial or not, while authorization is something which clearly and automatically submits to the coastal state control, which automatically submit to the coastal state control military navigation. Just because, there are Brazilian students and an Italian professor, Brazil and Italy are on the opposite side of these matter. Since Brazil, upon ratification of, but if I remember well, also upon signature already. Upon signature of UNCLOS, has declared that it interprets the provision of the convention in the sense that other states are not authorized to carry on military exercises or maneuvers, especially those involving the use of weapons or explosives within its exclusive economic zone without the consent of the coastal state. Italy, upon signature and upon ratification, declared that an opposite, a completely different interpretation, in the sense as I read the Brazilian declaration, I'm now reading the Italian one. The coastal state does not enjoy residual rights in the exclusive economic zone, and in particular, the right to obtain notification of military exercise or maneuvers, or to authorize them. So you see how differently states interpret these silence within UNCLOS. And another, for example, topic again concerning freedom of navigation is the issue of bunkering in the exclusive economic zone. As you know, the issue has been submitted to the tribunal for the law of the sea various times, in the very famous Saiga case in 1999, in the Virginia case, and the tribunal, there is a case still pending before the tribunal, which concerned as well bunkering. The problem here is if bunkering it is connected with the activities with the sovereign rights and jurisdiction of the coastal state, or it is attached to the freedom of navigation. Here, the tribunal in the Virginia case, which was a case between Panama and Guinea-Bissau, concluded that bunkering can be the control on bunkering is one of the measures that the coastal state may take in its EZ, but to conserve and manage its living resources. So it's the tribunal linked the control of bunkering to the conservation and managing of EZ living resources. While these connection, at the same time, the tribunal added that coastal states doesn't have such competence with regard to other bunkering activities which are not connected with, of course, bunkering of fishing vessels, to the protection of the living resources of the coastal states, EZ. And then we are on the high seas to conclude our survey of problems between theory and practice on freedom of navigation. And here, well, even in high seas, freedom of navigation is not without limitations. So on the high seas, of course, we have the realm of freedom of navigation, evidently. The high seas are open to all states, also land-locked states. Any state cannot purport any part to subject any part of the high seas to its sovereignty, and all freedoms must be exercised under the conditions laid down by international law. But we have the problem of even in a so clear discipline, we have some interpretative problems. We know that the counterpart of freedom of navigation is given by the exclusive flag state, the exclusive jurisdiction, the exclusive flag state jurisdiction. So these two terms seem to us extremely clear. Freedom of navigation and submission of every vessel on the high seas to the jurisdiction, legislative and enforcement jurisdiction of its flag state. But first of all, what does it mean, freedom of navigation? And when the freedom of navigation is violated by a state different, other than the flag state. So let me just mention some case law which illustrates rather well the interpretative problem. We know that freedom of navigation is the freedom of a vessel to traverse the high seas, to move along the high seas with no interference by any other state different from the flag state, but also no minimal interference. Let's say that if we read read scholars, and also if we analyze the claims submitted by states to international courts and tribunals, we see that not any interference is considered as a violation of freedom of navigation. But usually states contest interference, which physical interference, which has reached a certain threshold. For example, in Volga case, Russia lamented certain activities put in place by Australia, which were activities such as boarding the Russian fishing boats, the detention by the military personnel of the fishing boats, and the diversion of the fishing boats under escort towards an Australian port. So you see a rather important interference. For example, the Netherlands objected before ITLOS the boarding, the investigation, the arrest, the detention again of the Arctic Sunrise by the Russian authorities in this turn. So freedom of navigation on the high seas is the freedom of movement within the high seas without interference which produce an alteration of the route by the vessel. So very small, irrelevant interference which do not produce these important effect maybe are not a violation. They are not contested, first of all, and they are not maybe probably a violation of freedom of navigation. But ITLOS, in its judgment in the North Star case, again, this case, Panama against Italy, it said that if enforcement activities occur in internal waters, but for activities conducted on high seas, in that case, freedom of navigation, Article 87, is violated. So why? Because there is a sort of indirect expansion of criminal, internal domestic laws to the high seas by a coastal state. So the fact that an enforcement activity is conducted in internal waters, but having in mind high seas, can be, according to the tribunal, a violation of freedom of navigation on the high seas. Of course, I won't speak, because you know of the limits of freedom of navigation established by UNCLOS, which concern the right to visit, the hot pursuit, and so on. What I wish to emphasize before ending this lecture is, UNCLOS admits limits to the flag state jurisdiction, but if provided for by UNCLOS or other treaties. What is interesting is that we don't have, except the agreement on straddling stocks, we do not have any multilateral treaty establishing such a limit, in the sense that states are so in favor of the principle of freedom of navigation and its counterpart, the exclusive jurisdiction of the flag state, that they haven't been yet able to negotiate any real exception outside UNCLOS to that principle. So if we think about the UN Convention on the illicit traffic in narcotic drugs, we find a mechanism to obtain, to rapidly obtain the consent by the flag state, but not the possibility to avoid the consent of the flag state. The same through different mechanism, we have in the 2000 protocol, Palermo Protocol on to the protocol, London Protocol, 2005 London Protocol to the suppression, concerning the suppression of unlawful acts against the safety of maritime navigation. Also, in this case, we have tools to have more rapidly, in short time, the authorization by the flag state to interfere with the navigation of a vessel if there are suspicions that it is engaged in this sort of activities, but the consent is always necessary. And the same in the 2000 protocol, Palermo Protocol, concerning the smuggling of migrants. Again, we have a very articulated article which try to let the consent by the coastal state easier. And the last mention, think of the very famous PSI initiative, the initiative launched by the United States. Brazil is not part to that declaration, which started as a political declaration, which is the Proliferation Security Initiative, a sort of common understanding between the participating states to fight together against the proliferation of weapons of mass destruction. Well, the initiative try to, but it is not binding, I repeat, is a political declaration, mention the goal to avoid the consent by the flag state, but at the end to have let functioning this initiative, the United States concluded a lot of bilateral agreements with other states where it is established the possibility of interception by U.S. vessels, warships of merchant ships of these states. Well, the only body which has few times overcome the need for the flag state consent has been the UN Security Council. While exercising its powers under Chapter 7, the UN Security Council has authorized states to board and investigate foreign vessel in some cases. Of course, the UN Security Council adopted proper resolutions to that end. One case is, for example, in the Libyan case, where the Security Council admitted the boarding of vessels on the high seas after certain cautions are taken to avoid the smuggling of migrants. So this very important violation of human rights, and of course the trafficking of weapons off the Libyan coast. So just to conclude, freedom of navigation has a long history, but it is still a fundamental principle which hasn't remained as the beginning with Grotius, but has had the capacity of evolving along with the new needs manifested by coastal and flag states. Thank you very much.
Thank you very much, Professor, for your technical and illustrative lecture. Thank you very much. It was very, very good. Well, the students, Tatiana, Tainá, have some question to address to Professor Ida.
Yes, I'm ready.
Thank you, Professor, for your lecture. I have no questions, but it was very interesting, and I like it very much. Thank you.
Thank you. Thank you. I'm happy. I'm happy. You know, the best compliment for a professor, best compliments to professors come from students.
Of course. So, we have a question in YouTube from Soraya Fontanelles. I will read for you, Professor.
Yes.
At first, it's an honor hearing this lecture from a judge from ITLOS. The delicate matter of the military vessels was commented, including the authorization demanded by some coastal states. The American freedom of navigation doctrine is an isolated position. The limitations of the military innocent passage inside territorial waters is a consolidated state practice, bearing in mind that USA is not an UNCLOS member state.
Yes, so if I have well understood, if there is a question or more a statement, of course, the US are not a member states of UNCLOS, so they are not bound by their rules. The rules contained, in UNCLOS. But we must say that several UNCLOS rules are customary in nature, so it's not the case to enter in a discussion on which rules are of course customary or not. What I can tell you is that the problem of military navigation is not a problem completely solved in a sense or in another sense. There are really, we can say that we have stayed in favor of a complete freedom of navigation everywhere for military vessel, and states not in favor. We don't have what, in my opinion, definitely solve a problem is a judgment when an international court or a tribunal is rules on this matter. We have a different position. All these positions, of course, most of them have very solid foundations. Other more fragile, but they are, of course, claims, and we don't have had yet any, let's say, interpretation authoritative from an international judge, which would be very helpful. I'm speaking as a professor, of course, now, not as a judge. We all know for a long time I was a counsel, so I plead before international courts before becoming in preparing the pleadings, the written pleadings and the oral pleadings, to have the case law in favor is something extremely important, because gave substance, I will say, to the arguments. In that case, we don't have a case law. And so have opposite interpretation, which are all, of course, well sustained in international law. Of course, it's not a single state which can decide but it is, of course, the international community as a whole.
Yes, and I understand that in such an important issue, it would be important to have a multilateral position. Even case law and a multilateral position in terms of diplomatic negotiations. So we don't have in this case.
Yes. We don't have, so
sure.
We are just, let's say, reasoning all on that issue. I summarize it very, of course, dramatically, of course, because for reason of time, but it's an open issue. So we would need a multilateral approach, which will, but international law has this way of creating new rules. Let's say yes. States are sovereign, and so they need to find their way. And this takes a long time, especially in a very, let's say, rich international community in thinking and opinions like the contemporary one.
Yeah, sure. If you allow me, I would like to ask you a question regarding environmental case law in ITLOS. The part 12 of UNCLOS related to the protection and preservation of the marine environment as a whole wouldn't be considered as a restraint of the freedom of navigation, especially if we analyze Article 194. Wouldn't be a restraint, an opposite of the...
I missed your voice because I have a very low connection. So
okay.
Sorry, I hear only the last part. So if you repeat, sorry,
I will
just
repeat
when
it.
was speaking, the line was very poor.
Okay, sorry. I will summarize. Wouldn't be the part 2 of UNCLOS, environmental protection, a restraint of the freedom of navigation principle? And how to address international state responsibility in a case of marine environmental damage by a vessel during an innocent passage. I don't know if you got it.
So
I can repeat.
Here, let me repeat, and because the connection was a little better, but still poor. So it's a case, if I understood well, is a case of a vessel which causes an environmental damage during innocent passage in the territorial sea of another state.
Exactly.
I think that so if the coastal state can intervene to that end, let's say, I think that in environmental action is something which is nowadays eroding the freedom of navigation in some way. We even reading UNCLOS, we see that several exceptions are to the freedom of navigation are connected with environmental protection. So if we think that in case of pollution, the passage is not anymore innocent. If we think that criminal jurisdiction or civil jurisdiction can be exercised under Article 27 and 28, take into consideration the link between the passage and the territorial community, probably there is room for thinking that the coastal state has jurisdiction over pollution in territorial sea. We can also reason, taking it into consideration, the role of the coastal state within the EZ concerning pollution. Here, I think the protection of a state against pollution is something which is, as I told you, limiting in a certain way the flag state principle, but it is not limiting it contra legem, let's say, but it is limiting it praeter legem, let's say, or praeter legem, as Anglo-Saxon say, in the sense that UNCLOS gives some legal basis for that. Think that, just to give you an idea, that in the Mediterranean Sea in the past, some states, Italy and France, so two big states within the Mediterranean, established ecological protection zones and not EZ, because they were more interested in the protection of the environment than in the protection of their fishing resources, which are rather poor, and so they can be exploited in a very a strict way under the European Union rules and regulations. So think how strong was the intention of protecting the Mediterranean coast, that they first established ecological protection zones, and then after some years they changed them from ecological protection zone to complete exclusive economic zones.
Yeah, and this is a kind of a tendency in ITLO's case law, in a way.
In a way, well, it seems so.
Yeah, and in domestic and regional tribunals, courts.
Yes, we have this very strong feeling again towards environmental protection for several reasons. Think about plastics, microplastics, and climate changes, and all these very dangerous aspects which endanger the entire international community, not the interest of a single state, but the interest of all states.
Yeah, absolutely. Well, we don't have questions on YouTube, and I don't know if we have questions from our students here. If we don't have...
No more questions.
No more questions.
No.
Okay, Professor, on behalf of the organization of the International Winter Program of CEDIM, I would like to thank you very much for your brilliant lecture and for your time. And hope to see you at CEDIM future events. With that, I declare the session closed. Thank you very much for everyone who watched. Thank you.
It was a great lecture. Thank you, Professor. It was a pleasure having you with us today.
Thank you very much, Professor.
Thank you, Professor Bárbara.
I wish you all luck and have for each of us, the organizers, the students, and for the course. So have a nice time, and I hope to see you again.
So bye-bye.
Thank you. Bye.
Thank you to you all. Bye-bye.